Okay, so some common issues that come up in your interactions with your client is the topic we're going to be talking about today. The first thing that I think is important to understand is that as lawyers, we understand that there's a scope of our representation. Just because a client comes in and pays us a retainer obviously doesn't mean that we're subject to their every question, represent them in every field. We understand that. But the important part of this is that most clients don't understand that. Now, if you're dealing with more sophisticated lenders and business people, they probably do. But your typical person, especially if they haven't used a lawyer in the past, isn't really understanding the concept of the scope of the representation. And unless you nail that down with the client at the very beginning of the representation, you're going to have some problems. And the first thing you have to understand is it's your responsibility to define the scope of the representation and to communicate that to the client so the client understands that what they're paying for is a specific legal service limited to a specific set of facts. And the only way you're really going to be able to do that is in writing. Now, every state jurisdiction is different in terms of what's required of you as a lawyer. Some will require a written full retainer agreement. Sometimes it's a letter of representation. Sometimes it depends on the amount involved. But I would say, as a good practical advice for a new lawyer, develop a full retainer agreement right now. Take the time to really put together, it doesn't have to be that lengthy, 2 or 3 pages of boilerplate that it specifically addresses the scope of representation. Then you can just use that template in almost all of your cases. You won't have to keep rewriting it every time. But if you spend the time to begin with, you're going to have that in writing. And it's a good idea at the beginning of the representation to talk about that with your client. This is what I'm going to be doing for you. This is how our fee arrangement is set up. And anything outside of this arrangement has to be set up by a separate retainer agreement. Once you explain that, most clients don't have a problem with it. And it assists them too because they know what they're paying for. The second thing I would want to address in terms of your relationship with your client is sometimes you're going to have conflicts with your client. What I mean by that is your client wants to do something that you think is not a good idea. And there's different ways to handle that depending on what we're talking about here. First of all, if we're talking about something that you believe is unethical or even illegal, now you're into the canon of ethics. The professional code of responsibility will guide you in your jurisdiction, and I would urge you, if that ever comes to play in your case, and probably will at some point, where you really feel that this client is asking you to do something that either you can't ethically do, or your client might even be engaged in some kind of illegal conduct. Every jurisdiction has adopted the professional rules of responsibility, but they're all tweaked. So you first have to decide, what is it that your jurisdiction requires? Generally speaking, the canon of ethics, the professional rules of responsibility, will tell you that you need to first try to talk your client out of that, especially if it involves things like, he or she is going to perjure themselves. Should be all kinds of red flags there. Your first duty is to try to convince your client, this is illegal, I can't participate in this, you can't participate in this, and I'm trying to convince you to not do this. Sometimes that's not going to be available to you. The client is going to be dead set on doing whatever they had in mind. At that point, again, you have to use the professional rules of responsibility in your jurisdiction. Many jurisdictions will tell you have to go to the court, and you have to ask the court to be relieved as counsel. And that causes all kinds of problems because what do you tell the court? You can't tell the court, well, my client is going to perjure himself. You also have the canon of ethics that regard confidentiality. you're kind of stuck. A lot of times when you're making those applications to the court, you're saying things like, you know, my client and I cannot agree on the proper course of action. Something nebulous. Most courts kind of see through that. They understand you got a problem and you want out. Like I said, that's guided by the professional rules. If it's something that's ill-advised, it's not illegal, it's not unethical, but based on your view of the law and the facts of the case, you think what the client is proposing is really not in the client's best interest. Unless it's something that you feel very strongly about, you don't necessarily have to get out of the case. But here's what I would do. I would sit down with the client and say, look, I've explained to you that I think this is a really bad idea. I don't think this is in your best interest. I don't think we should take this tactic. And so we're going to proceed based on your instructions, but I want you to know why I think it's a bad idea and what I think is going to happen if we engage in this course of conduct. And then reduce that to writing and make the client sign off on it. Because if something down the road that doesn't go right, and the client comes back and says, well, he told me to do that, you're going to want to have that to protect yourself. The last thing I want to talk about is your due diligence based on what your client has told you. And the mistake that a lot of new lawyers make is, it's true because my client said it's true. Let me tell you something, and this is common sense, but that's not true, and your client will tell you all kinds of things that aren't true, leave out facts that are important. And I can't tell you how many times I heard in court a judge say, counselor, why do you think that's true? Well, my client told me that. That's a really bad answer. You need to do your due diligence based on what your client's telling you before you repeat it to the other side, and certainly before you repeat it to the court. You make the client prove to you what they're saying. You don't just accept it because your client has told you that it's true. So those are three things that I think you should keep in mind. Some of the three things, the issues that come up in your interaction with your client.